Hopefully, everybody had a chance to peruse the packets that they received in the mail. If so, look for a motion to approve the agenda as printed. Motion by Laura,
Second.
second by Kurt. All those in favor say aye.
Aye.
Opposed? Motion is carried. Thank you. Next is approval of minutes from December 17th. Anybody have any additions or corrections? Hearing none, look for a motion to approve.
So move. Second.
Motion by Ezra, second by Brad. All those in favor say aye.
Aye.
Opposed? Motion is carried. Is there anyone in the audience that wishes to speak on something that is not on the agenda? Is there anybody in the audience that wishes to speak on something that is not on the agenda? Is there anybody in the audience that wishes to speak on something that is not on the agenda? Hearing none, we'll move on to the next thing. We have a Fargo-Moorhead diversion update by Mr. Eric Dodds.
Okay, good evening. Thanks for inviting me here tonight, or maybe Matt did the inviting, but my name is Eric Dodds. I work for a consulting firm called AE2S. I've been a consultant working on this project for, I think, 13 years now, and the last 5 years or so have been focused more on the lands portion of the program. So wanted to cover just kind of a few general updates. Maybe you guys are familiar with some of the activities on the project, and then eventually I'll get into some items that may be more interesting to the planning department. So brief project overview. This is just a picture of the outlet structure where the channel meets the Red River up near Georgetown. You can see on the bottom left side of the screen, that's the weir outfall structure that meets up with the Red River. The project, of course, is being designed to help reduce the flood risk in the FM area, really be able to pass 37 feet through town with a 100-year flood and be able to fight a 500-year flood that would pass 40 feet of river stage through Fargo-Moorhead. On the left-hand side, you can see the existing 100-year floodplain. All the light blue color is the existing 100-year floodplain, and then on the right side, you can see where a majority of that floodplain from the improved area, the protected area, is removed. Of course, there are some impacts the project will cause, primarily upstream of that black zigzag line on the south side of the project. A brief few slides here on a construction update. These are probably a month or so old, but nonetheless, you can see that overall about 61% completed with construction. The P3 work is really the diversion channel and the associated features with the channel. That's about 56% complete. The federal work is the southern embankment, so that's the black line on the previous slide there. The black line on the south end of the project, that's the federal work, so that portion is about 68% complete. And then there are some remaining in-town levee works in Fargo and Moorhead that are about 80% complete. The Diversion Authority did put this slide together to showcase some of the construction progress that was made in 2024. Lots of numbers on the slide. I guess pick your favorite number depending on how interested you are, whether it's 28 million cubic yards of material excavated from the diversion channel. Again, I think there's about 40 million cubic yards total to be excavated, so they're well over halfway on the material excavation. 3,500 trees have been planted, ongoing. Lots of numbers there. I won't go into all that. I'll spend just a little bit of time here talking about the southern embankment. That's a portion of the project that affects Clay County. So the southern embankment really starts south of Horace, over on the, I guess, left side of that map in the middle. The southern embankment is about 22 miles long. It includes 3 different control structures. The diversion inlet structure is just south of Horace. The wild rice structure is right along I-29. And then the Red River structure is on the Red River, of course. There are a number of transportation features, including the I-29 crossing. That I-29 was raised a few years ago. That project is now complete. There are a number of county and township crossings that cross the southern embankment. In Clay County, there will be crossings at 130th, 140th, 150th, and then 160th, which is the Comstock Road. So every mile north of Comstock will have a crossing over the embankment. Just a little bit more detail about those three big control structures. So this is the diversion inlet structure that's just south of Horace. This is essentially complete. The Corps is just continuing to work on some gear mechanism issues with the gears that roll those gates up and down. The Wild Rice structure, about the same situation. So again, this is right off of I-29. You might see it if you're driving south of Fargo on I-29, essentially complete. And then the Red River structure is about 70% complete. This is the largest of all the structures, of course. All three of these were built by Ames Construction under contract to the Corps of Engineers. The southern embankment in Minnesota, there's two segments. Reach 4 is the north-south segment, so that starts at the Red River and goes south to the county line. And then Reach 5 is the east-west segment that follows the county line. The Reach 4 started construction earlier this year, really started this fall, so they haven't made a ton of progress yet, but they are out there moving some dirt and making a little bit of progress. They've suspended for the winter now. Reach 5, again, is the east-west segment. That will begin construction later this year in 2025. Getting into some of the real estate side of things on the property acquisitions, overall in the construction footprint, we're nearly 100% complete. The only thing that's not complete is final value conclusions on a few eminent domain parcels. Unfortunately, we haven't been able to reach voluntary agreement with everyone, and so there were a number of eminent domain actions. We do have all the property rights, and so construction is ongoing, but the valuation of those is still determined through the court process. On the upstream mitigation area, that's really the area where we have an obligation to purchase an easement that allows us to flood or allows the project to intentionally flood some of those areas. That comes with payment, of course. It allows farming to continue. We're approaching 60% complete on those upstream mitigation area flowage easements. In Minnesota specifically, about 2/3% complete. These pie charts that I'm sharing here, we produce these every month and share them with a board formed between Moorhead and Clay County that are responsible for purchasing land in Minnesota. That's the MCCJPA you see on the slide title. Zooming in a little bit more detailed on the Minnesota side for property rights. So we've acquired property rights to 160 of those parcels. There's still a number of them that we have a value that's still pending. A few of those are in an active eminent domain status, and some of them are still ongoing negotiations. Don't need to go into all that detail unless you're interested, but just to give you a snapshot of that, again, we do report this on a monthly basis to the MCCJPA. Spend just a little bit of time here talking about our mitigation plan. So we call this the PRAM, Property Rights Acquisition and Mitigation Plan. This is a document that really outlines our land acquisition programs and plans that will help us purchase the property, help mitigate the impacts to property owners. The PRAM includes information about how we're going to do those acquisitions. It's really been kind of a living document. The first version of this was published back in 2016. We have had 5 different versions, and the 6th version is nearly final, and that's really what prompted us to come here tonight. As we work on finalizing the PRAM documents, the DNR and the DNR's counterpart in North Dakota are 2 of the agencies that do some review of the document. Again, this has been in the works for quite a number of years. The PRAM has modified a bit as the project changes. Years ago, we had a different alignment to the project. That's been resolved, and the alignment has been established since late 2019. You can see just sort of the evolution of the PRAM and an evolution of the project with this series of maps here. On the left-hand side, that was what we called Plan A. So years ago, the embankment went basically straight east in Minnesota. Then there was a version, PRAM 4, that was actually approved by the DNR several years ago. Version 5 has been approved by the state of North Dakota. And currently, we're working on version 6, which adjudicates all of the differences between those versions and tries to reconcile that moving forward. So version 6 of PRAM is, again, fully reflects what we know today as the comprehensive project. It incorporates all the mitigation requirements from both the state agencies, the federal government, as well as the settlement agreement that the Diversion Authority established with upstream stakeholders. It aligns the previous versions with the permits that were approved by those state agencies. It adds a bit of a crosswalk so that, like the DNR, for example, if they had approved version 4, there's a crosswalk between that version and version 6, so hopefully avoids any confusion. One of the provisions that the DNR included in its permit was related to development downstream of the embankment. So this is condition number 45 in the DNR's Dam Safety and Public Waters Work Permit. That last sentence that I've highlighted, the DNR recommends that local government units adopt requirements that no development be allowed within 1/4 mile of the dam or along river channels. So recently, as we were reviewing PRAM version 6 with the DNR, they asked what steps the Diversion Authority had taken to handle this permit recommendation. The Diversion Authority shared with the DNR that we had sent letters. Well, the Diversion Authority doesn't itself have any zoning authority. And so the Diversion Authority took the position that we would share this recommendation with all of the zoning officials. So City of Horace, Pleasant Township, Stanley Township on the North Dakota side, Clay County here on the Minnesota side. And so back in 21, this letter that you see, and I don't expect anybody to read that, but this letter was shared with the Planning Commission, shared with Matt, and basically just explained that those were the permit conditions, that the DNR and the state of North Dakota had a similar permit condition. The Diversion Authority, I thought I would highlight this one paragraph that just acknowledges that the Diversion Authority, again, does not have zoning authority, and as a result does not have the ability to enact or enforce zoning ordinances. Therefore, the authority does not intend to make any additional planning and zoning recommendations for your political subdivision beyond those that were identified by the states as a recommendation. And so the letter went on to just acknowledge that the Diversion Authority is available and happy to present, happy to meet and discuss this matter with you. As we were reviewing the DNR's recent comments on the PRAM, I brought this issue up to Matt, and Matt asked if we'd come and just give this group a brief presentation about what the DNR's recommendation was, and maybe plant the seed with you for some future consideration. So this is a map zooming in on the southern embankment. The yellow highlighted portion is the 1/4 mile buffer. It's really just intended for illustration purposes. The blue on this map is the 100-year floodplain with the project. You can see there's portions of the embankment that will not actually be touched by water during the 100-year floodplain, especially down kind of in that southern location south of Comstock. There's portions of that embankment that will not be touched by it. This next map then shows different flood events. So the dark blue is the 100-year, the medium blue is the 500-year flood, and then there's a light, very light blue that is what's called a PMF. And that's basically a biblical type flood, probable maximum flood. So lots of information there. I think my goal tonight was just to share an update about the project, share an update about the PRAM, and introduce this 1/4 mile recommendation. Again, this was a recommendation from the DNR. I don't know that the DNR or the Diversion Authority have any ability to demand or enforce any of these zoning restrictions. But with that, I'd stop. That's all I had for you tonight, but I'm happy to answer any questions.
Mr. Chair, thank you for coming in, Eric. Very informational. I don't have any questions, but that's food for thought, I guess, what the DNR asked.
I'll probably let Matt maybe guide you guys through next steps if you have any, and I guess happy to stay with if you've got any questions.
Yeah, Eric, I guess one question for you is if you could have any other jurisdictions adopted any zoning, and if so, what have they kind of done with this recommendation?
Sure.
Do you have any information on that?
Yeah, good question. So Pleasant Township in North Dakota has adopted a zoning restriction. Theirs is kind of a two-part restriction. Anywhere within 450 feet from the toe of the embankment, they have development restrictions. Anywhere within 350 feet, no buildings. So there's that 100-foot swath between 350 and 450 where they would allow non-residential construction. They really don't want anybody, sleeping, having living quarters anywhere in 450 feet, but they could allow non-residential within that between 350 and 450. And that's from the toe of the embankment. So, you can imagine the embankment comes down where that toe meets ground. This map that we're showing here on this screen is illustrated from the center line, and I guess those are nuanced details that you may get into from a planning and zoning standpoint. So Pleasant Township has adopted that. Pleasant Township is, I guess, south of County Road 16, if that means anything to you. I'm not sure how familiar you are, but the County Road 16 is, I'm trying to draw, if you know where St. Benedict's Church is, it's south, so that main paved road south of St. Benedict's, that's the start of Pleasant Township. Otherwise, we have had some very high-level discussions with staff at the city of Fargo. They control zoning over a portion, a real kind of a small portion of the embankment on the North Dakota side. They haven't made any conclusions or determinations. The staff have just anecdotally commented that they also would probably prefer not to have residential zoning right up against the embankment. But I think they are open to having industrial or commercial or something, again, non-living quarters adjacent to that. But that's maybe just talk. I don't know that they've really had any detailed discussions about it yet.
So I have another question for you. So with that embankment being built, how far out did you buy out of buildings and residential houses along that? I mean, is it a half mile right now with nothing being built in that area, or?
We only purchased property rights for the footprint of the embankment, and then on the wet side, we purchased the easements, but nothing on the dry side.
So there could be stuff currently within that quarter mile?
There are, yes, I believe there's a house up on the north end right near the Red River structure, and then along the east-west county line, there are a couple structures just north of that embankment. Yeah. And I guess I should point out the east-west portion, the existing road is by and large going to serve as the embankment. They will be reconstructing a few portions of that road. There was a lot of design details that went into geotechnical testing and stability of the roadway itself, but the majority of that road will serve as the embankment. So while we say it's under construction, it might look like there's not a whole lot going on. One day it's a road and poof, the next day it'll be an embankment. So that was technical engineering speak.
Yeah.
A question on a 100-year flood and a 500-year flood. How much water would be contained on the embankment, and how close is it to the top of the embankment?
I don't know if I have those numbers at my disposal, but I would say the top of the embankment is about 928 and a half feet. And under a PMF flood, The water surface elevation is about 923.5, so there's 5 feet of freeboard at the PMF. From the 500-year flood, I believe the 500-year is 922.5, and the 100-year flood is 921.5. So you're talking 7 feet of freeboard at the 100-year flood event.
So, Mr. Chair and Mr. Dodds, ultimately, the purpose behind the recommendation is essentially a dam safety. Yep, okay.
Yeah, and I guess maybe just to add on to that, I'm not sure how much this goes into detail, but the DNR, I think, recommended this because of that. What if the dam would ever breach? The breach analysis that was conducted concluded that if there was ever a breach, the water would dissipate both velocity-wise and depth-wise within a quarter mile. And so I think that was why they stuck at that quarter mile recommendation.
We've had at least one solar panel array that we've talked about in the last couple of years, but I don't remember how far away we placed them.
Yeah, Mr. Chair, that's pretty much almost right up on the dry side of the dam. And I think at that time, that's something we had consulted with the diversion authority about too, to see if there'd be any issues with that. And just judging by the fact that it's just kind of solar panels elevated a little bit, there wasn't any issues at the time with that.
I can add a comment on that as well. We've been approached by a solar farm developer in Wilkin County, just south of the county line. And they are planning to build a solar array, basically right where that yellow bar kind of turns and makes a jog to the east, just kitty corner southwest of that. There's a solar farm being planned in that location. And we were able to coordinate with them to make sure that their panels were high enough to stay out of sort of harm's way of the flood, and their control boxes would be high enough and things. So that was an area that's actually in one of our flowage easements, but we felt like it was much like a utility pole or a power pole. It was acceptable at certain elevations.
And Mr. Chair and Mr. Dodds, is there any recommendation for the county to do any zoning on the wet side of the dam at all? Or is that essentially with the flowage easements in place, when they are in place, would that essentially restrict any development?
Yeah, so in that location, the flowage easements, a little bit hard to tell. I'm seeing if I got a better map in here, but the flowage easements in Clay County are what we classify as Zone 1, which Zone 1 is our most restrictive flowage easement, and it prohibits any development. It prohibits any existing structures or any development. And so I think the easement itself should restrict development. Obviously, the Diversion Authority or the MCCJPA is the easement holder, and so we have some obligations to enforce those easements. There are other easements that do allow some development. And for example, in Wilkin County, we've been in contact with the zoning floodplain administrator down there and had some good back and forth. So as she's reviewing development applications, she knows what her rules are. And we've got a connection where she'll call and ask us if it's in compliant with our flowage easement. So I think there is probably, in Clay County, again, our flowage easement restricts any development. So that might be sufficient. I could see from a planning and zoning standpoint, if you wanted to take some other consideration, that maybe that's a belts and suspenders, but
Anybody else have any questions or comments for Matt or Eric? Thank you for coming in. It was very informative.
Thanks.
Yeah, so Mr. Chair and Commissioners, I was just, tonight was just kind of a informative kind of session for you all, just to kind of understand where the project's at and maybe some potential impacts on the Minnesota side, as well as some potential action that the county could take in terms of zoning in the future. And just a question for you all, is this something that you'd want to maybe consider further discussion on in the future? We absolutely can do that.
I think we definitely should have something in place sooner rather than later.
Yeah, and one thing that I could prepare to for you is just kind of looking at maybe a potential development build out scenario for residential development in this quarter mile, just to see if there wasn't anything in place, how many residences could potentially be constructed in the future, just in terms of our density limits and things like that, as well as what's currently there. I think, as Eric mentioned, I think there's only 3 houses right now kind of in that buffer. Also, considering some other questions about looking at what other jurisdictions have done. Sounds like no one's gone the full quarter mile, so there's some options there. And then options for other types of development as well.
And I was thinking, why would we do the bare minimum? I was thinking, well, wouldn't a half a mile be better for housing development? You're putting 50 homes in there, then 900 yards is better than 400 yards.
Well, yeah, that's a discussion that could be had as well. Yep.
Thank you. Okay, hearing nothing further, we okay to move on, Matt?
Yes, Mr. Chair.
Like to look for a motion to open the public hearing to discuss the Clay County Land Development Ordinance.
So moved.
Motion by Ashley, second by Sebastian. All those in favor say aye.
Aye.
Opposed? Motion is carried. Public hearing is open.
Thank you, Mr. Chair. Let's see, gotta find the most. All right, so in December, we had gone through our development code chapters, or development ordinance chapters 1 through 4. Certainly open to any discussion on those chapters as well. This doesn't have to be limited to chapters 5 through 8, just now that you all have had some more time to review some of those chapters. If there's anything that you want to discuss further, again, just a reminder, those chapters are covering kind of the purpose of the ordinance, defining what development is, nonconformities, and the establishment of zoning districts. Chapter 2 covering our base zoning districts. So we have 4 base zoning districts in the county. We have agricultural general, our agricultural service center, limited highway commercial, and highway commercial. And then our overlay zoning districts. This would include all the resource protection zoning districts, as well as our flood hazard areas and shoreland zoning districts. I had mentioned this before in the past, but the state will need to review both the changes to the flood hazard or the floodplain ordinance and the shoreland ordinance. And so that will be taking place here in the near future. I don't foresee any huge issues with either of those reviews, because kind of our intent with amending those two, specifically those two parts of the ordinance, was to make them more in line with the state shoreland and state floodplain rules. So they should actually be more in line with them. And the state has provided pretty good model ordinances to follow for those. Feedlots is the other one that the state needs to review. And again, that has been modified to essentially reflect what's in Minnesota rules and statute for feedlots as well. Again, in chapter 4 too, with this is probably our biggest chapter, having the use table, which looks at what uses are allowed by zoning district, and then different use regulations for different types of development. It's probably the lengthiest chapter, looking at agricultural, residential, commercial, industrial, recreational, public service, utility, accessory, temporary uses. So some changes to our like renewable energy ordinance, which includes wind and solar. Used to be that was adopted in 2018. That was a standalone ordinance. That's now been kind of folded into the land development ordinance as well. And then some other big changes, just to remind you there, with one that you as a board hear a lot about is, or make a lot of decisions on, is the interim use permits for a second dwelling on a parcel. And so allowing for a accessory dwelling unit, that was kind of the other big one change there. Is there anything, any questions or concerns from anyone on chapters 1 through 4? I don't think this would be your last opportunity to. If you go home and in the coming weeks are reviewing something and have a concern, you can definitely contact me, and I can bring that to the board.
You are going to have a public hearing at this meeting, correct? When it's all done?
Yes. Yes, I think we should have a public hearing on the full. Yep. Yep.
So if we don't see it right now, and we do see it later,
Yes. Yep. And I would say that in terms of where we're at with this draft, is it's essentially completed and just really looking for comments and input on that. And so maybe that's a good reminder for me to kind of back up. We can certainly have that public hearing in February. I know there's been some interest of the board to have a work session on the ordinance as well. And that's up to the board chair, Commissioner Kevin Campbell, if he wants to call that, where the board will kind of workshop the ordinance, not at the regular board meeting, but that's open as well to the public or to planning commissioners to attend.
Have we already passed the deadline to have a public hearing at the planning commission for February?
No.
No?
That's coming up though.
Yeah.
Yep. But if you think that that's a good time to have that, we certainly can. We could also wait until March and let some of the comments come back from the state on some of those other.
That'd probably be better.
That might be a better idea.
Get all those comments in.
Yep. And then also any comments that come out of a work session if that were to happen.
Yeah.
Yep. And then after a planning commission public hearing, then it would go to the board. The board can have one or as many public hearings on the ordinance as they see fit. All right. With that, I can jump into chapter 5, development standards. And I'll just kind of walk through this memo that I had sent out to you all, just because it kind of highlights the the biggest changes. We do also we are tracking all the changes that would be key changes in a spreadsheet as well. And it just gets into a lot more detail. Probably the biggest thing or one of the big things in Chapter 5 for development standards is that in our code right now, we have a provision about lot setback averaging. And so with lot setback averaging, essentially how that works, and I can try and find a good example of it maybe, is you would be able to say a road setback is 125 feet, and your neighbor has a house at 100 feet. Your next door neighbor has their house at 100 feet, and the neighbor on the other side of you has their house at 90 feet from the center line of the road. You could take the average of that 100 feet and 90 feet, and that would be your setback for building. It wouldn't be 125. We're suggesting removing that. I don't know what you think. The rationale behind that is it kind of perpetuates nonconformities. It's something that's used in cities quite a bit, not really in counties. I personally could take it or leave it. I don't think that there's any harm in keeping it, because usually the differences are so minor. I just want to get your thoughts on that.
If we get rid of it, could they still come to the Board of Adjustment and get a variance on that?
Yes.
I support removing the averaging portion of it and keeping it at 125, because we do see on the Board of Adjustments and here for people, they could use that as an argument.
Sure.
But I'd like to get things to conform.
I should say that from if you're on a lake, for example, and you have a neighbor in the same situation where the setback is 150 feet from the lake, and your neighbor's at 100 feet and your other neighbor's at 90 feet, you could use that to build closer to the lake. That's in the state shoreland rules. The other thing and maybe I can just go to it, show you, is we tried to combine all of the development standards. These are just the general standards that might not apply to, these are for our base zoning districts, like Ag General, that's like 80% of the county. All the development standards into one table. And so the goal here is to have this just be more accessible, as opposed to just writing it out in more of a narrative format. Getting all your setbacks, minimum lot areas, what kind of subdivisions could be done as well. The one comment that I had on here is we currently don't have a minimum lot area for highway commercial and limited highway commercial districts. Here, there was proposing a minimum lot area of 1 acre. The only time where I could maybe see that being an issue is if someone wanted to do a common interest community. And a common interest community would be something like a shop condo, where your lot is basically part of a building, and then you would never have, that'd be a crazy shop condo if every unit in the shop condo was an acre in size. So that's might be somewhere where a minimum of an acre could be, it kind of seems maybe a little arbitrary, but I did want to get your thoughts on that.
I think there's other standards that would make, if we do get rid of, if we go back to having zero minimum on that, there's other standards there that would make that lot for parking and stuff like that, that would make that lot at a size conforming to the building that's on there. Correct? I mean,
Yep, correct. And there could be it could be something as simple as if you're doing like a common interest community or something like that, you're exempt from that because you're also probably not going to be able to have a minimum lot width of 100 feet as
Yeah.
well. That's just a very specific example, but I just know it's something that has been proposed in Clay County before. And it's just becoming a more popular model of development.
I would personally leave that as not having a size there on what. There's other standards there that can make that lot bigger or smaller.
Okay.
Would that be similar to like a PUD?
It could be, but with a PUD, you can essentially, with a PUD, and we don't have really anything for PUDs right now except in shoreland, but with a PUD, you could basically deviate from allowed uses, allowed and other standards, basically in exchange for doing other sorts of I don't want to call them concessions, but you might do additional things that would allow you to do that, and that's how a lot of mixed use development gets done in urban areas. Say like a PUD, you could have, you wouldn't be able to. You could say with a PUD, not adhere to a minimum lot area or a minimum lot width or anything like that. But as part of your development, you might have to have like additional screening. You might have to have additional open space, for example. You might have to have some architectural design standards for your construction. So it allows for more flexibility in development, but there's usually a development agreement that would take place between the local jurisdiction, in this case Clay County, and the developer. Does that answer your question? Okay. For county roadway access standards, that is a large part of this chapter. Basically, it was essentially updated to it was pretty minor updates. Our county engineer, Justin Storm, and I did take this to our highway tracking committee. So that's a committee that basically is made up of 2 commissioners and staff, and they review matters related to the county road system. And I don't think we had any major updates to it, just clarifying some language. And I don't know, Justin, if you have any comments at all on it.
Not really. We just had to, in the past, kind of reference 2 different documents, so it's just kind of cleaning it up and putting it in one spot.
Yeah. So there was, at one point, there was a county roadway access policy, and then there was also what was in our code, and there was just some discrepancies between the two, and that's kind of been reconciled here. There's been some updates to parking and loading standards. Get through this. So I think the big thing with this is that if you ever have concerns about parking with a use that's coming before you, you would have the authority then. Now it says in here, you can require a parking study to be done. And with parking, I don't think that's this is something that's more common in municipalities or urban areas, but it's something that could definitely come up, so. And there is kind of a table that shows kind of the minimum parking spaces for different types of land uses. One of the other bigger changes in this section relates to signs. So some language in here that's essentially that stating that, you know, the county is not regulating content of signs in terms of the First Amendment rights and things like that. There are some signs, though, that we would prohibit, like something that's illegal, something that's sexual in nature, something that's made to look like an official traffic sign, signs that are video, thinking signs that would maybe be a health or a safety hazard, essentially. The big thing with signs is changing the setbacks. We're looking at changing the setbacks to 10 feet off the right-of-way of public roads. Right now, our sign setbacks are the same as structure setbacks, which kind of defeats the purpose of having a sign if you're going to have a sign. If your sign needs to be 125 feet off the road, well, no one's going to see it, and if they do, they're probably going to crash their car craning their neck trying to look at it. So making that more reasonable while ensuring that they stay out of the right of way. Also allowing for some off-premise signs. Right now, we don't allow any off-premise signs in Clay County. But allowing for, there's businesses that, and this is common in other counties in Minnesota as well, where a business might want to have a sign that, you know, show, because they're not on the main highway or something like that. An off-premise sign would allow people to see kind of where to turn for their business. So almost more directional in nature, not necessarily advertising. Excuse me. There are some exemptions to this, or exceptions to this. Would be that along state roads, these would not be permitted just because they're the road authority, unless they meet their requirements. Billboards, allowing them as a conditional use in our highway commercial districts, and some standards for that as well. And then any questions on signs at all?
Are you following state rules on those billboard, on the setbacks and all that?
Yes. Yep. The final section that's new in development standards is the requirement for just site plans. Detailed site plans, if you're submitting a permit application, it should contain these features if applicable. The whole purpose of that, I think, is to give you, or whether it be myself looking at a development permit for a new building, or whether a applicant submits an application for a use permit before the planning commission, just ensuring that you have, the applicant provides all the information that you need to make an informed decision. I think this is something that's kind of maybe been lacking in the past, just kind of the absence of a detailed site plan. And I think it would help you all immensely to have that. So just making it a requirement in the ordinance is kind of the easiest way to ensure that happens. And this is also reiterated in chapter 4 as well, for the different types of uses that would come before you, whether it be a commercial use or an industrial use or something of that nature. So this is, it's kind of a little repetitive, but just kind of want to make sure that, yeah, this is an important thing that needs to accompany an application.
Mr. Chair and Matt, could go back just a little bit. Highway commercial and limited highway commercial, do you have a map that actually shows where that is?
Yes.
And my question is, any changes in that, does that mesh with the cannabis? Is production and grow, it can only happen in those areas, right? Does
Correct.
that affect that at all, what you already have in place?
It wouldn't contradict it at all.
It wouldn't?
No. So the yellow here is just shows all of the cities in the county. The green is our highway commercial, so there's some outside of Holly, and then kind of along the Highway 10 corridor. There is some as well kind of around the city of Moorhead. And then on 75, there's this darker green is that limited highway commercial. So there is some limited highway commercial just south of Dilworth and southeast of Dilworth and east of Moorhead.
Okay.
And then there's also highway commercial within the city of Downer. So not a whole lot of highway commercial in the county. Any questions on chapter 5? Concerns? Comments? Okay. Chapter 6 and chapter 7. Okay, we'll start with chapter 6 is subdivisions. So this chapter has gone through a group of staff who deals with all the land records related matters in Clay County. So the auditor's office, our GIS and communications, our assessor's office, and then recorder's office as well. So they've all reviewed and provided comments on this. This chapter, as well as the following chapter, will also looking at having them reviewed by a land use attorney, just because things can get complicated with subdivisions and also with administration and procedures. So we're looking at a land use attorney to be outside of, it's been reviewed by our county attorney's office, but then also who's done a fantastic job of reviewing it, but just having a second set of eyes with a firm that's solely almost focused on zoning and land use.
Have you sent it already off to them to look at it?
Have not sent that yet. They are the firm that puts on all of the land use trainings,
Okay.
essentially for,
Right.
yep.
That'd be good.
So we just did some terminology changes. What the major subdivision plating process is required for. And the major subdivision plating process is that process where a plat would come before the planning commission and then go to the board for approval. Also added some just updates, so we're in compliance with Minnesota statutes 505 and 519B. 519B is the Common Interest Communities statute. Do want to ask for a point of discussion is right now in Clay County, before anything can be done in terms of brought before the county in terms of platting, if there's going to be new right-of-way, it can't be a private road, it has to be a public road. Typically, the township has to adopt that road. What we currently have in our current code and in our proposed code is that there's township approval and maintenance agreements required for the platting of a new public right-of-way. And I am just wondering if we should maybe broaden that a little bit to just township pre-approval, because the township does have every right to deny a plat. And if they were able to get that at the front end, as opposed to going through the process only to have the township not sign off on the plat, might save a lot of time and effort. The reason why I bring that up is there are statutory requirements in 505 that basically says that a board, so the county board in this case, cannot approve any plat of land lying in a town which is appointed a planning and zoning commission unless the town board approves the plat and the laying of streets and other public ways shown in it. And this approval shall be endorsed on the plat and signed by the chair of the town board. Not every township has a planning and zoning commission. A few do, but not every single township has that. And so my thought is, as opposed to just make it a kind of blanket, because every township does ultimately have to sign off on a plat. And that would put our code in compliance with state statute, and then also would give the developer the opportunity to go, or the township the opportunity to hear about this plat on the front end, as opposed to sometimes on the back end. Sometimes that happens, and I think it would just save developers time as well.
I also think townships would want that.
Yes, I would agree.
Yeah, and the township should have it first.
Yep, okay.
You need to talk to your LGUs before you do anything else.
Yep, okay. So that's something we can tweak to,
Yeah.
that's an easy tweak. That was kind of the main topic that I wanted to, or point that I wanted to discuss there, so. So for chapters, any other questions on subdivisions? Okay. For chapter 7, administration and procedures. So chapter 7 essentially is what kind of defines the roles and procedures for permitting and for land use decisions in the county. So starting with the zoning administrator, so what myself and our staff, what our duties are, the county board, the planning commission, the board of adjustment, defining what a development permit is, variances in the variance process, conditional use permits, interim use permits, text amendments, zoning map amendments, appeals, and then violations, penalties, and enforcement of any zoning infractions. And so with this, we also talk about one thing that I wanted to make clear here is that the planning commission would be making environmental impact statement needs decisions and environmental impact statement adequacy decisions. That's how, in my review of how these decisions have been made in the past, that's how it's been done, but it's not in our code. So bringing that into our code, that's something that I want to check with that the attorney on, just to make sure that that's correct. Also, some changes to our appeals process, making them more clear, because it's currently not very clear in our current code, our current ordinance. Just for use permit decisions made by a planning commission, the applicant could appeal to the Board of Commissioners, and then any other aggrieved party would appealing to district court on that, as opposed to going to the board. The exception of that, well, I shouldn't say the exception. For any decision that's made by the Board of Adjustment, the Board of Adjustment is they have final say on variances. So if someone wants to appeal a decision by the Board of Adjustment on a variance, they go right to district court. There's no avenue to go to the board.
Do you want to spell that out in this?
It is, yep.
Okay.
Yep. And then just a section, just a new section, just establishing that right to appeal and clarifying that appeal process and who reviews it. The other change would be more specific action, enforcement actions for violations. So looking at like administrative penalties and fines. I know that this is something that the Planning Commission has talked about a lot, especially with some of our more maybe intrusive land uses or more visible land uses and some permit condition violations that have happened in the past. So this essentially doesn't set like a fee schedule or anything like that, but it gives the county board kind of the framework for determining what that what the administration or administrative penalties and fines policy would look like. And then also, there is some ambiguity with use permits and violation of conditions. Technically, for an interim use permit, for example, if there's one violation of a condition, the planning commission can have a hearing to revoke the permit. That oftentimes does not give the permit holder an opportunity or the ability to try and rectify the violation. So a thought here was to kind of do a 3 strikes rule with violations, giving people 3 chances to rectify a violation, and if not, then it would go before the planning commission to make a decision on permit revocation. Potentially, one of the benefits to that is it gives permit holders the opportunity to correct these violations, but also if they are not corrected, it gives you as a planning commission a kind of a history of how that permit holder's actions, and would hopefully help you all make a better decision on the status of that permit.
Staff would work with the applicant on those, establishing what the condition they're failing to meet, and then working with correcting it, and if they don't, then there'd be violation after violation after violation.
Yes, yep, until the point where it would automatically trigger.
Trigger to come back.
Yep.
All right.
Yep. As opposed to it just being at kind of the discretion of staff to do. There's something in the code that says, okay, we've reached this threshold. Now that's going to trigger you coming before the planning commission to have a hearing on the status of your permit.
Mr. Chair, I'm not, kind of along with Commissioner Bear's question. These first, second, and third violations, is there a schedule? Is it all negotiable, or is there, like, first violation, there's a cost involved or a penalty involved? Or you just give them 3 chances?
That's something that would have to be probably developed in policy by the board, in that administrative penalties and fines, they certainly could, they might be able to do that. That's something that I also would like to talk with the land use attorney about, because when you start assessing monetary penalties to permit violations, that's something that I would want to be absolutely sure that we can do that. Like, for example, state agencies can do that.
Yeah.
But it's not very clear or like your municipalities can do that. But it's not entirely clear if counties are able to do that, or if the process is just the permit revocation. That's the only process.
Be nice to have it in writing what the process is if they come into the first or second violation before they get.
Yeah, and it's typically would be like you have so many days to correct this violation, and if you haven't done it, then it would maybe even constitute, say it's a first violation, and they have 30 days to correct it, or they have 2 weeks to correct it, whatever. It should vary a little bit, because some things are like dust control, for example, not being applied, that might be different than a condition about reclamation, something that might take a little bit longer to actually do. And so, if they have a first violation and then a certain amount of time lapses and they have not fixed it, that could be the second violation. Yep.
And my question on that, so would that need to come to the board for the first strike, or would staff? You know, so it's in public record, so it's in writing, who determines, does it have to come to the board to be a first strike and a second strike?
Staff would determine that.
I think, yeah, we would determine that. And then after, if it did come to the planning commission for that public hearing, those 3 violations would be presented. The planning commission could ultimately make a final determination, say, well, no, that wasn't actually, we don't think that actually was a violation.
Okay, thank you.
And any administrative decision that's made, I should note too, this is in our current code, but any administration decision that's made in terms of approving a permit, denying a permit, or making a decision on correcting a violation, the applicant always has, or the permit holder, applicant, whoever it might be, excuse me, always has a right to due process, and that due process right is through the Board of Adjustment. The Board of Adjustment handles appeals of administrative decisions. So there is a body that, if they say, no, that wasn't a violation, there is a body that can hear that. It's like if I get a speeding ticket and I want to contest it in court, that, yeah.
And by putting it in writing here, if there's a new planning director and a whole new board here, we have something to go off.
Yep, and it just makes it very clear for everyone.
Yeah.
All right, any other questions on that chapter? The final chapter is definitions. Essentially, it's an attempt to define everything that would be noteworthy or in the ordinance.
I have one to add there. You have one for, it's windbreaks or shelter belts. Add the opposite one in there. I think you have shelter belts as a definition. I don't think you have windbreaks.
Add them both.
Yeah, make sure both of them, because they're both talked about.
Yeah, and that's something we did talk about. Yeah,
Yeah. So
shelter
yeah.
belt.
I don't think windbreaks is in there.
Nope. Get that in there.
Because I know there's different setbacks to windbreaks and shelter belts. So.
One item for potential discussion here, or 2 actually items, is with the definitions, with the renewable energy definitions, the feedlot definitions, the shoreland definitions, and the floodplain. Within each of those sections, there are definitions in there as well. And when we can, we have just left those definitions in those sections. Couple reasons for that. One is, especially for shoreline and floodplain, it'd be nice to be able to just take those out. Whenever those are 2, the floodplain and shoreline are 2, I'll say, zoning districts, where people want to find that information and that information only, and they want everything that pertains to it, to floodplains and shoreland, in one section.
Yeah.
So that was the thought there. Also, they have specific meanings. The terminology might have a specific meaning just relative to shoreland or relative to floodplain. So the thought was to keep some of those separate. We also just did that for the renewable energy. And And then feedlots as well. Especially with feedlots, there's very specific definitions too that would apply only to feedlots, and same with that. Where we could, we just referenced in in this chapter, say you wanted to find something about floodplain. We just put flood and related terms, see this section. That's where the definitions are gonna be for flood and related terms. That's kind of how I just want to get your thoughts on that. Would you prefer that, or would you prefer to see just all the definitions in the definitions section? We could do it in both. We did, in the rules, the first section in this, just did make note that these definitions are in other sections too, just to make that clear.
And I would support the way you have it, so it's quite overwhelming, the definitions that you have already, and now throwing those 4 groups in there in addition to, a lot of hunting and more efficient.
The other thing that the plan consultants suggested that we just decided to do is every term that that is defined in the ordinance is capitalized throughout the ordinance. So if it's capitalized, you know that if it's capitalized and it's not like a what's the word I'm looking for? Proper noun? It's been a while since English. It's going to be in one of the definition sections. And I know that did cause some confusion, like when our county recorder was reviewing the subdivision section. She was sending me some messages and saying, like, who wrote this? There's some grammar issues going on here. And it's because I didn't explain to her that the defined words were capitalized, so.
Do we have that mentioned in every chapter, at the beginning of every chapter, stating that?
I don't believe so. It should be. I think
Should
it's
be.
mentioned somewhere, but it needs to be clear.
Yeah.
Yeah.
'Cause otherwise, everybody's gonna look at Clay County and their grammar mistakes in this.
Yeah,
you
that's
know?
true. Yeah.
So yeah, as long as it's present and it's very
Yep.
known that is what.
Yeah. I definitely will put it here and put it at the beginning as well,
Yeah, and maybe it'd be
and maybe every chapter.
every chapter, because if you're only going to one chapter to look
Yep.
at.
Yep. It's been, I don't know, it's maybe a little too, could be a little too complicated.
Maybe a different font on those words.
Yeah. That might be italicized, am I right?
Yeah. I don't know, or
Yeah. Or just leave them as is. Don't do anything with them. Don't capitalize.
yeah,
Yeah.
maybe the font thing, or nothing, and let people go hunting.
Yeah.
Ask the attorneys on land use. They maybe have come across what they do with that.
We could also ask Erica what she thinks about that.
Yeah.
Yeah. Yeah. It's a lot of work to go through and easy to miss some
Yeah,
too.
maybe just leave them all standard and then we don't miss any of them.
Yeah.
Then we don't worry about it.
Yeah.
Then we don't have to have notice on every
Yeah.
chapter.
Yeah.
That's probably better. Now you gotta make sure to change them back that you don't miss any.
Yeah, that's true.
How far are you? 50%? What really?
Pretty much all the way.
It'll be easier to do.
It'd be easier to go back and just grab the ones that haven't been capitalized.
Yeah.
'Cause
That haven't been.
That haven't been at this point.
at
Yeah.
this point. So maybe you do that route.
Yeah, we might just have to leave them at this point. Yeah.
Leave that up to you guys. Staff can decide what to do.
Sounds good. All right. Any other questions on this chapter or any other chapters? Yeah, this won't be the last opportunity, but now we kind of have a full draft that's out there. I've had a couple opportunities to review, and yeah, in March, I think now this will give you all some, if we have a set a public hearing date for it, would be March 18th. I think that would give ample time for review.
As long as the attorneys get back to you, I'd
Yep.
hold off until.
Yep.
Mr. Chair and Matt, I like the fact that you're making it as easy as possible for someone to come in and find it, look at it, see it, understand it. I've never had to search through pages and pages, but whatever you can do to make it simpler, easier to find is, I think, a great thing to do.
Yeah, and that's one of the whole goals too, is just to, I mean, just by their very nature, they're gonna be complicated, but to try and make them as accessible as possible, I think is key. One thing I should note too, and I have to give kudos to our GIS and Communications Director, Mark Sloan, on this, is we're moving the company that does our codification. So the codification of the entire county code will be going to a new platform. And when that happens, it will be integrated into the little search bar here on the Clay County website. So if you're searching for something like building setbacks or something like that, the code, relevant sections of the code should pop up in your search results. And that currently does not happen. I think that'll make things a lot easier for folks as well.
Chair and Matt, can I back up to administration and procedures?
Yes.
Just for a second. The 3 violations, how many violations do you guys get a month?
It depends on the year or on the season, really.
Okay.
I would say currently and it also depends on if it's just a building permit violation or if it's a use permit, like a violation of a condition of a use permit. There are some, depending on the use, where we could go out and do an inspection at one site and find 5+ violations at one location.
Sure. Okay. I was just wondering, I kind of go back to, I don't know who mentioned it, I don't know if it was Dave or Joel, not bringing these issues each time there's a violation, but just letting us know, hey, there's a violation, this is what we're doing, this is the timeline, like at each one of our meetings, just so we know, so we're aware. So if somebody comes, within our area and says, hey, we put this in, we don't know what's going on with it, it would just be kind of a nice tidbit. It could be a 5 minutes before, during our meeting, so we know what's active out there, but we're not acting on it until strike 3.
Sure. No, I think that's a very good idea, Commissioner Hang. It's something we could do is we could at each meeting just give you some stats on violations, and not just limited to use permits, but building permits and everything like the like. So
Just
that's
a quick one, I don't want to add to any, I don't want to add any.
it's something we're tracking anyway. So yep.
Yeah.
Maybe just put something in the packet instead of it's not on the agenda.
Yeah,
Yep.
and we're aware and.
Yeah, could do that. Could also do, and this is maybe getting a little off topic, but also stats on just building permits too. By township or, yeah.
Put it in the packet. And
Yep. right. I don't know, Mr. Chair, if there's anyone, I don't think there's anyone online, but there might be folks in the audience too who might have some comments on our, we did send notice out to all the townships and then all the cities in Clay County too. And we will do so for the next meeting as well.
Okay, is there anyone in the audience that wishes to speak? Please come to the podium and state your name for the record, please.
Looks like it's on. Hello, my name is Matt Racel. I'm with Moorhead Township. So yeah, we got this letter just saying that this was gonna be discussed tonight, so very interesting discussion. There's just some notes in here. I think they must be on chapters 1 through 4. And I just had a couple of really quick questions. The first one, it talks about these accessory dwelling units. Is there like a specific definition of what those are? Is there like a size limit? Is there, can it be just a trailer you throw down? Is there, I'm just wondering what counts as that?
Yeah, that's a great question. So in the definition, it's a separate complete housekeeping unit with a kitchen, sleeping area, and full bathroom facilities located on the same lot as a single-family dwelling. In terms of what the standards would be, let me open that up here. So some general standards just being that it'd be one per lot, have a minimum size of 150 square feet, has to be detached, must not surpass 75% of the principal dwelling, has to be on a permanent foundation. There's some placement considerations, septic, and that's essentially kind of.
Okay, so it's not a tent, not a camper just thrown up there. It's a little more permanent.
Yep, it has to be on a permanent foundation.
Okay.
Yep.
All right, very good. And then the other question I had is mentions that, for certain structures, there's a limit with foundation and a limit without. Let's see, there would be no permit required, which is fantastic. I love that idea. My only question with that, I was thinking about it when we're talking about setbacks from the road, is how would we ensure it, or how would it be ensured then that those meet those requirements? If there's no permit at all, is there some kind of mechanism? Is there like a quick check that has to be done to make sure that they're at least meeting those setback requirements?
Yeah, Mr. Chair, and that's where it can get a little tricky. The only thing that we have in there to make it that enforceable is that there is a clause that essentially says that all accessory structures must meet the required setbacks.
Okay,
So if there is something that does not, and it cannot be moved, then it would be essentially treated as, well, you have to move it. You could try for an after-the-fact variance. Those would kind of be the options for that. So they wouldn't be exempt from the setbacks per se. They still have to, there's language in there that would state they have to meet the setbacks.
okay. All right, very good. That's all I had for questions. Thank you.
Okay, is there anybody else in the audience that wishes to speak on this matter? One more time, anybody else in the audience wish to speak on this matter? Hearing none, look for a motion to close the public hearing.
I'll move.
Second.
Motion by Ezra, seconded by Ashley. All those in favor say aye.
Aye.
Opposed? Motion is carried. Thank you. That was a good discussion. Lots of information. Unfinished business.
No unfinished business.
Okay. And on to new business.
I guess this maybe could have been unfinished business because we have talked about it a couple times now, but again, reiterating that we're having our election of officers at our February 18th meeting. So I haven't seen anyone campaigning actively for that. I haven't seen any signs. I haven't gotten any phone calls. So just know that that's coming. And then, Brad, your first term ends in February. So we can talk if you want to give it another 3 years or not, and go through that appointment process again. But
You will.
that's all the new business that I had.
Thank you. And again, the next meeting is February 18th, where we will elect officers. Anybody else have anything else to bring before the board? Hearing none, look for a motion to close the meeting.
So moved.
Motion by
Second.
Sebastian, second by Ashley. All those in favor say aye.
Aye.
Opposed? Motion is carried. Meeting is closed. Thanks, everyone.